name is Roseanne Plante, and I'm an attorney and an active member of the Fawn Lobbying Committee. And today I want to tell you a little bit about the bill that we'll be sponsoring. When a marriage ends, the relationship ends, but the relationship with the children does not. What our bill attempts to do is level a playing field that right now is not level for both parents. The most important thing about our bill is the fact we're introducing something called a rebuttable presumption. So what does that mean? Well, that means currently when a husband and a wife go to court and they're divorced, one party is declared the winner, the best parent. And it's by a preponderance of the evidence, and it's up to the judge. What we want is to make sure that the Iowa law is clearly followed in the fact that it is in the best interest of the children. What we want is to strengthen Iowa families. We want children to come out of a divorce not scathed. What happens are these children, they can suffer lifelong effects from this, and that is not healthy for our Iowa families or the future of Iowa. It's the highest form of scrutiny when the Supreme Court looks at it, which means that it has to be clear and convincing evidence. But in Iowa, when we look at who is the best parent, it's a preponderance. It's a much, much lower standard. With our bill, not only would we have the rebuttable presumption, but judges would have to look at clear and convincing evidence why that parent should not have shared parenting. Gone would be the days of mudslinging in court. Not only would this be better for the parties, the court system, and the children, but it would save money in the court system, move cases along more quickly, and make divorces far less contentious. So we have several people who have expressed concerns about our bill. One major concern is how would it affect if there's domestic violence in the relationship? Well, we're glad to say that this bill will not affect it at all. If there's any domestic violence, neither party will be forced to go either to mediation or be forced to engage in this rebuttable presumption. The parties would be able to not have it held against them if any party needed to move away. That wouldn't be held against them if they were fleeing the situation or the community to keep themselves and their children safe. So we're pleased to announce that this would have absolutely no effect if there was domestic violence in the situation. Nothing would be denied to the judge to hear that as evidence. One great example of how our bill could affect Iowa positively is Kentucky currently has this shared parenting idea that we're trying to introduce. What has happened is that there's actually been a great reduction in domestic violence. Why, you ask? Well, because the parties are working together, both with the mediation or the rebuttable presumption. People feel that they are both getting a say at the table, therefore reducing conflict, reducing anger, and therefore reducing any domestic violence situations. So actually, once again, our bill would do not only strengthen families in the fact that both parents would get to share in the joys of raising the children, but anxiety and anger toward each other would be greatly reduced, therefore also reducing the domestic violence risk and statistics. So let's talk about what shared parenting would do for Iowa families. In addition to the fact that the children would just have access to both parents, and just imagine this, you're a child under the age of 10, and all of a sudden mom and dad are no longer in the same house. Not only are they no longer in the same house, they're not talking to each other, and maybe they're not even in the same community or town. Think how that would affect you. Your everyday existence as a child is all of a sudden ripped from you. This is why children experience anxiety, depression, and fear. So shared parenting not only takes that stress away from the child, but it also brings the joy back to not only the child, but the parents. Imagine this, if you've never been divorced or you don't have children, that one day you go from a household with two parents who are actively supporting and nurturing the child, and that means everything from going out and earning a living to tying shoes, kissing boo-boos, going to plays, going to Girl Scouts and Boy Scouts, and all of a sudden you're the parent doing it all. And maybe your divorced spouse has had to move away to take a good job to pay the child support, and all of a sudden you are left with everything. All the doctor's appointments, all the dentist appointments, every parent-teacher conference, everything is all of a sudden on you. This shared parenting would take that stress off just one parent. Currently, when the court systems award custody, There are two types of custody. There's joint legal custody, which means each parent has a right to make decisions about the child. That means if the child has to go to the hospital, you can sign the permission slip for surgery. But what joint legal custody does is creates a battle. It creates a battle at the school, at the doctor's office. And why do you say that? That's because each parent has equal say. So if you have a parent that walks in and says one course of procedure, maybe for an injury, and you have another parent who wants another thing, what's happening are doctors and schools are saying, you have to go and work this out. We can't take two different decisions. And oftentimes these parents who are so upset with what's happened in the court system simply won't agree on anything. So shared parenting would bring them together in situations like that. It would help truly make joint legal custody joint. But then on top of that, what happens is one parent is awarded physical care, okay, primary physical care, and the other one liberal visitation. Well, the primary physical care parent is the one doing the day in and day out care of the child, and they can become very stressed and exhausted from it. Shared parenting not only helps the child, but it helps the parents. And with less stressed parents, we have less stressed children, and we have a better functioning family unit where everybody still feels like a family, even if we have a divorce decree in place. Another concern about our bill is that somehow one parent is seeking shared parenting because of child support. That is absolutely a myth about this bill. Child support would not be affected. What would happen is, in the mediation or by the judge, both parties would submit their income just like they do now. And if one party makes significantly more than the other party, an offset will be given. And that's exactly how it is now. What that means is if you have a very high wage earner parent and somebody who makes quite a bit less money, the higher earning parent would do the offset. So perhaps $200 or $300 would be paid to the parent who makes less. Now, if the parents happen to make about equal amounts of money, then yes, no parent would pay to the other parent any child support, but it's still going to be looked at. Nothing on our shared parenting here takes away the legal duty to support your children monetarily. So there is no concern about child support. In addition, people would say, well, perhaps you'll ask for shared parenting just because of that. Remember, in this bill, one person has to ask. If, for instance, that they don't want to ask for it, the proceeding would go exactly the same, and child support would be figured exactly the same as it is now, which means both parties, no matter what, have to submit a financial affidavit either in a divorce or a modification or a custody. So child support is not affected at all. Really, some of the best child support you can have is just that, support of the child with time. A parent who's paying child support but only sees the child maybe 2 or 3 times a year if they live a distance away, or only every other weekend, that's only 4 days out of every month. Wouldn't it be better to have shared parenting, an offset of child support if it needed to be, and more time spent with the child? One thing that keeps coming up about our bill is that shared parenting would result in, of course, 2 homes. And many people have thought that that would pull the child between the 2 homes. I have a personal story about that I can even share. My parents were divorced in 1972, and my mother was awarded physical care of me. Because of the fact there was some distance between myself and my father, he simply chose not to exercise his rights because, for exactly that reason, he didn't want me pulled between 2 houses. The opposite is exactly true. Studies have shown that children that have 2 homes and 2 supportive parents have double the support. They have usually in each home a room that's theirs or an area. And what it does is it creates 2 safe havens for the child. I also have clients that have told me that, in fact, after they engaged in shared parenting, they realized how wonderful it could be. They realized that they could work together. They realized that they could rely on each other if one needed to have some time for business or to go out of town, the other parent could step up, that they really worked as a team. And it ended up that most of the time the child forgot what the schedule was and went freely between both homes. I spoke to a father recently who's actually over the age of 70 and engaged in this at a time when it was unheard of. And he said, I spent far more time with my children. The heavy visitation turned into shared parenting that was unknown at the time back then. And he said, my children told me that I saw them far more than the children whose parents weren't divorced. So shared parenting is really a no-lose situation and only a win situation for the child and both parents involved. Another thing that would be solved by our bill is what's called the Disneyland parenting. What this means is if one parent only has the child 3 or 4 days a month, or even more tragically, just once or twice a year, obviously that time is spent having a lot of fun, therefore calling it the Disneyland parent. It's nothing but fun because the parent feels extreme stress to make sure that the child has a good time in the very short amount of time that they have together. Shared parenting would do this: bring back reality. Mom and dad each have the child an equal amount of time. This gives them an opportunity to not only have fun, but have downtime, have normal time. And as will happen, every child makes mistakes and needs to be corrected. This leaves the parent the actual opportunity to discipline their children, instill values and morals in the child, give them the time to let the child think about if something that they did was wrong, and to guide them better. This gives them actual time to nurture the child. Where a Disneyland parent, it's very rushed, it's in, it's out, we'll do some fun, and it's a snapshot. Shared parenting is not a snapshot, it's the long run. And that's what this bill would help us do. One thing we want to make sure that everybody understands is that the parents in shared parenting need to be fit, able, and willing. We also want to make sure that people understand that there are still the protections in this bill that there already exist, which means protections if there are sexual abuse, domestic abuse, or child abuse. If any of those situations are in the relationship, this bill would not apply. And also, it's very important to realize that though this bill, we hope, is passed, that the parents have to invoke it. If either party does not ask for this, the rebuttable presumption will not exist. So it's voluntary. It's voluntary in the fact that if one party asks for it, then it will be considered. If neither party asks for it, or the court decides that there is an issue where it shouldn't be applied, this will not be forced on any couple who is attempting to either divorce or set a modification order. Let's also talk about the different standards that would be changed. Right now, when a judge looks at a family law case, they look at a preponderance. Now, a preponderance, if you're wondering how that's considered, is I like to picture the scales of justice. A preponderance means the scales just slightly tip, and the judge feels that there's just a slight reason why one parent should be considered the primary parent over the other. In this bill, if rebuttable presumption was invoked and requested by one party, if the other party disagreed, they would have to present clear and convincing evidence why there shouldn't be shared parenting. So what would be some examples of that? Well, perhaps we have an absentee father, or perhaps we have somebody who has not nurtured the child, somebody that has been steadily unemployed and will not be supportive of the child financially, somebody who has never taken physical care of the child at all. But they would have to be clear examples, not just parties getting up on the stand and mudslinging. It also would require parties to hire experts, not just the family counselor or the church pastor who doesn't have any experience. If somebody truly felt that one parent was lacking in parental skills and it was affecting the child, they would have to bring forward an expert witness, perhaps a child psychologist with training and degrees and certifications, who has assessed the child and presented a report. That would be an example of clear and convincing evidence that a judge could consider, not just simply mom or dad getting up on the stand, or grandma or grandpa, or aunt or uncle saying, we don't think the other parent is fit. If you'd like to learn more about our bill, and we really hope you do, we have several resources available to you. FamiliesUnite.org is our website where you can go and learn more about the bill, see the actual pros of the bill, and comment about the bill. And you can also look at Iowa Legislative Recommendations 2020 on our website. If you have comments or questions, please contact either myself or any other FAWN committee member. We love to hear your recommendations, and we look forward to your support in the 2020 session.